All rise. The Court of Appeals Division 1 is now in session.
Good afternoon. Thank you. Please be seated. Thank you for your courtesy. This is the time set for oral argument on our case captioned Merchant Cracchiolo and others versus the Honorable Robert D. Myers and others. Number 1, SA 150013. We've allocated 20 minutes aside. As you know, if petitioners want to reserve some time for rebuttal, we ask you to watch the clock and tell us when you're ready to sit down. We'll try to honor that. We have reviewed the arguments and issues and conferenced the case, and we think we're ready for oral argument. We have some questions for both sides, I'm sure. And if each of you, whoever's going to argue, would state your name as we routinely ask when you start, that'll help if somebody's listening to the audio recording. And having said that, let's see. We also have in this case, as we did in the last case, an unresolved motion for leave to file under seal, which I think we're going to grant. But if either of you wishes to take a moment or two to talk about that, feel free to do so. We are also inclined, I will tell you, to accept special action jurisdiction. But if you want to talk about jurisdiction for a few moments, that's fine too. But if not, we're inclined to do that and then issue our ruling thereafter. Having said that, we are ready. Ms. Gabbardine?
Good afternoon, and may it please the Court. My name is Chelsea Gabbardine, and with me are Mark Harrison and Nathan Aerosmith, and together we represent the petitioners, Bertrand Cracchiolo, Michelle Lund, Kristen Lund Olson, and Karen Lund Page. I hope to reserve about 5 minutes for rebuttal. This case raises the question whether a litigant may deprive its opponent of the fundamental right to counsel of her choosing through a motion to disqualify, an extreme and disfavored remedy in Arizona, on the basis of documents which opposing counsel does not have and cannot use to defend himself. We submit that the answer to that question is no, and that here Bradford Lund waived his attorney-client privilege with respect to those documents in the Jennings-Strauss file that he contends should disqualify Bertrand Cracchiolo from further participation in this probate case. If the rule were as the trial court had set up below, we would be requiring trial court judges who are generally unfamiliar with the context and history of the case to decide the crucial prejudice issue in the context of disqualification in essentially a vacuum, without the benefit of the competing arguments on the prejudice question. This is not good for the adversarial system. It is offensive to the due process protections that exist for litigants' right to counsel of their choice. And it is inconsistent with the requirement that processes that will deprive a litigant of the counsel of their choosing must be fair and must be meaningful. We contend that it is especially harmful here, where the petitioners were deprived of the one firm and really the one lawyer who has been with them for the life of this case, a complicated and long case.
Well, obviously you disagree with Judge Bassett's ruling, but let me ask this, isn't his weighing of the harms here, which he comes out on the other side after doing that, isn't that really where this case is?
We don't think so, Your Honor. We're asking.
Do you then think that regardless of the weight of those harms, that the disqualification of counsel should not be an available remedy?
No, the harms is certainly a valid inquiry. The question of whether Bradford Lund is ultimately prejudiced by Bertrand Cracchiolo's receipt of these documents is a valid question.
But is it about the receipt of the documents? Is it about the receipt of the documents or what was done with the documents after they were received?
I think it's about the receipt and the review of the documents. In a lot of disqualifications, it does come down to counsel's intentional exploitation of the documents for its advantage and to exploit the privilege of the party who's inadvertently divulged the information. I don't think that is present here. The record below certainly doesn't evidence Mr. Murphy's intentional use of these documents knowing that they are privileged. But I do think that the Alexander inquiry and the factors there are the appropriate inquiry to make.
Do you have to know that they're privileged?
Do you have to know that they're privileged to be
Right,
disqualified?
you said that there's no evidence that he intentionally used them knowing they were privileged. And that caused me to wonder, what if it wasn't clear? What if he wasn't sure? Do you have to know that they're privileged, or is it the fact of the review that creates the issue?
Probably not in every case do you have to know that they're privileged, but it certainly is a factor for the court to look at. And the review is the focus, certainly, because we're talking about the harm, right? If you don't look at the documents, there's really no harm.
Right.
And we're essentially past that point. Whether Mr. Murphy actually looked at all of the documents in the Jennings-Strauss file was at issue at the special master level, we're past that point. If Birch and Cracchiolo gets the documents, they can't then take the position that they didn't look at them in the first instance. We're now at the heart of the disqualification question, which is, are these documents prejudicial? And is it a prejudice to Bradford to allow Birch and Cracchiolo to continue? So we're asking the court to move past the factual findings and afford the trial court, Judge Bassett's factual findings, no deference, not because of the weight and the evaluation that he made, but because it was premised on a fundamentally flawed process. As I've said, it wasn't good for the adversarial process to ask Judge Bassett, who is rather unfamiliar with this case, to decide this in a black box without the benefit of Bradford's position on prejudice and certainly without the benefit of Birch and Cracchiolo's position on prejudice.
I perceive your position is that, and correct me if I'm wrong, that you should have had, or Birch and Cracchiolo should have had, the documents so that they could argue more effectively whether there was prejudice or not. And there was no, and I guess along with that, your position would be that there's no prejudice in letting them look at the documents. They've already looked at them, and if the court finds what the court found here after this improved, you would argue, improved process, well, then they'll be disqualified. So why not give them the documents?
Yes, Judge Gemmell, that's it. If at the end of the day these documents are determined after a reasonable and fair inquiry to be prejudicial to Bradford, that is the end of the road. And there's no more harm to Bradford in having divulged them a second time because Birch and Cracchiolo is out. Similarly, if they're not found to be prejudicial, we're also no worse off for Bradford because the documents aren't prejudicial to begin with.
Is this decision as to whether Birch and Cracchiolo gets to look at the documents in order to defend against the disqualification? Is this decision one that we are reviewing here? And if so, is it a de novo review or a abuse of discretion review?
It is de novo in the context of abuse of discretion. As I read the special action rules, the abuse of discretion is the standard. But under that standard, courts conduct de novo review of decisions of law. And whether or not Bradford Lund waived his attorney-client privilege by injecting these Jennings-Strauss documents into the issue is one of law.
Well, if we say Bradford did not waive the attorney-client privilege by filing the motion for disqualification and so on, then that's the end of your argument.
I think so. The waiver is what we stand on here.
So is it really the waiver, or is it the due process kind of argument that you needed to have the documents?
These are separate arguments. I don't think the court has to hold that a litigant has a due process right to counsel in the context of a civil lawsuit in order to find that there's been a waiver here. That's a separate argument, and one that I think is valid. We've cited to the court 5th Circuit, 11th Circuit, Oklahoma Supreme Court cases holding that there is, while not absolute, I recognize that, but there is a due process right grounded in the Fifth Amendment to counsel of one's choosing, and it can't be deprived absent a fair and meaningful process. But that second side, the fair and meaningful process, is really what our waiver argument is all about. And that's the fundamentals of the Hearn test, this sword and shield concept. You can't have it both ways. You can't affirmatively ask a court to look at privileged information, decide an ultimate conclusion of disqualification on that privileged information, but at the same time keep one side of the case from access to those documents.
Counsel, aren't there times when documents are so clearly prejudicial by the nature of the document or the content of the document that it doesn't require a hearing in order to make that determination?
I'm not familiar with any cases holding that. I could probably conceive of something if you get a hold of an email to your client, to opposing party's client, talking about that very issue, and it goes through, very facts at issue. Maybe then the court could look at it and say, there's just no way. I don't need to know what the other side's position is on this. There's just no way. But I think that in this case, there are real questions about the prejudicial impact of the documents, real substantive questions.
So you'll agree if there are attorney notes, attorney communications with the client addressing the strengths and weaknesses of their case, maybe even ultimately the fact they have no defense to certain issues, those wouldn't require to have a hearing in order for the court to come to understand that it would prejudice the person if the other side's counsel was able to remain in that case. No doubt about that.
Well, can I answer your question a little more nuanced?
You can answer my question however you want to. It's your time.
Okay, because if my hypothetical was two parties, two lawyers in the same case, same issues, and lawyer A comes across communication from lawyer B into his client on this case's issues.
I understand.
Okay. What we're dealing with here is a completely separate guardianship proceeding that was uncontested, that had separate counsel, that involved trust issues that related both to my clients, the underlying petitioners here, as well as Bradford Lund. So even though hypothetically you could look at a document and see that there is attorney-client notes, Birch and Cracchiolo should be able to say, number one, we knew about this stuff because our clients were involved in that issue. Or number two, this might look privileged and it might look tangentially relevant, but we're not focused on Bradford Lund's communication with his counsel. We're focused on the misdeeds that we allege the people who are in charge of him now are caring for. So it looks hypothetically bad, privileged, but these are two separate issues that we're talking about. So while I acknowledge that in a separate instance, if two lawyers if we have the hypothetical that I gave earlier, perhaps that could be the situation. But the rule we're asking this court to adopt is that any time a party seeks to disqualify opposing counsel on the basis of privileged documents, when that opposing counsel has received those privileged documents once before, that affects a limited waiver. A limited waiver that's only goes so far as to allow the other side to actually defend against disqualification.
That is a limited waiver.
Yes, a very limited waiver. And Birch and Cracchiolo can get the documents pursuant to a protective order. The O Builders case out of New Jersey, which I think both sides cite, is actually very instructive on this issue. It's instructive on the no harm issue, which we've been talking about. If the lawyer has had them once, there's really no harm in the lawyer having it again. And in the you can't have it both ways kind of a situation. You can't say, Your Honor, disqualify opposing counsel because they got privileged information, but I don't want to tell the other side what privileged information they got because that would offend my privilege. And the O Builders case says, no, you can't have it both ways, and it expressly contemplates providing the documents pursuant to a protective order.
Does that not set up that Hobson's choice situation that's been addressed in the pleadings, though? Doesn't that set up the situation where in order to protect the privilege, you have to give up the privilege?
It does, and it's okay in this situation. The Ninth Circuit in Bittaker,
Who?
it's okay to require a party who wants to put privileged information at issue to make that choice in the first instance.
And give up the privilege.
For a limited purpose, yes.
So the rule we are to craft is to protect the privilege, you give up the privilege.
Yes. To a limited extent, the privilege has already been divulged to that same party. What is the harm? The Bittaker case out of the Ninth Circuit says just that. It sort of creates that. It condones the Hobson's choice that we're talking about. It says, if you want to decide to litigate this issue, and the very heart of this issue touches on privileged information, then you're making the decision to waive it for that limited purpose.
What sort of ripple effects would that have then? Let's say, unlike this case, documents are, or perhaps like this case, depending on your perspective, documents are inadvertently produced the rule that you espouse has been adopted, so the recipient really has no interest or incentive to down tools when they're told to not look at them because they're privileged. Because the answer is, well, if you move to, disqualify me, I get to look at them anyhow, so why don't I look at them now? Is that, that's in a different factual setting, that's what the rule you're suggesting would direct. Is that the right thing?
Judge Thumma, I think that there are still incentives to follow the ethical rules, which require you to not look at documents you know to be privileged, know or should reasonably know to be privileged. The rules of civil procedure provide sanctions for knowingly looking at documents that are privileged. There are still motives to behave oneself.
And all those were in place, yet here we are.
If you look at the evidence below, there's no evidence that Mr. Murphy knew he was looking at privileged documents when he flipped through them for 5 minutes.
Which time?
When he looked at them, when he received them at the first instance.
Okay, this is when he pulled the diagram out?
Yes,
This was prior to Shumway's call?
correct.
Okay.
When he received the documents in.
I just trying to get the context in. Thank you.
Sure. So it's about my understanding is about 250 pages. He gets them, he flips through them for about 5 minutes is what his affidavit says. He sees that one page that grabs his eye and he puts them down. He makes a copy of that. No intentional violation there. He's asked for non-privileged documents. He gets the phone call from Mr. Shumway 3 weeks later, forgets about it, sends it out in a disclosure statement. No evidence that he actually looked at the file again. He just sends it out in a disclosure statement. And there it went to the respondents, and it went to the court-appointed investigator and the guardian ad litem. There's not been any argument that there's been harm to Bradford as a result of that action.
Does it matter who it went to?
I think it does.
Because?
Because
His privilege that he has the right to exercise and protect, if it doesn't cause him any particular harm by distributing them, you can go ahead and do it?
Well, Birch and Crackhill didn't share the documents with its client, for instance.
By sharing it with the attorney, don't you share it with the client? Can you distinguish the knowledge that the attorney uses in reviewing the documents from the knowledge the attorney uses in defending his client? Isn't it all
I think
in
it's
the same intellect and being used in the same fashion to aggressively represent his client?
I think that's where you go back to if these documents are ultimately determined to be prejudicial through a fair and meaningful process, disqualification happens.
Okay, thank you.
I think I'll save the rest of my time if the court has no further questions.
Very well.
Good timing.
Thank you, Ms. Gabardillo.
Good afternoon. I'm Jeff Shumway. I represent Real Party of Interest, Bradford Lund. Let me start with what they say they want the relief to be. If I wrote my note correctly and managed to bring it with me, what they say they want is that any time you bring a motion to disqualify, the other side gets the documents, but this is key, when the lawyers have already seen them. So here's the rule they want. If I violate 26.1 F2 and 4.4B, I get to see the documents again. If I don't violate them and I return them or sequester them or destroy them or file them under seal with the court until we can fight over the privilege and they bring a motion to disqualify, I don't get to see them. Judge Thuma's right. That is rife with incentives for a lawyer to review documents that have been inadvertently produced. Now,
Didn't that? I'm trying to get process down, and I think process does matter in this case. Wasn't there a complete evaluation of all documents that was undertaken once the motion to disqualify was provided? And that's why there was a complete analysis by Mr. Murphy at some point of all the documents.
yes, in
It
fact,
was after your notice to him, and at what point?
Your Honor, if you have your clerks look at tab 2 Exhibit 2, we provide a timeline. And that timeline has references to the record so that you know that we're just not making stuff up. And here's what happened. November 14th, we filed the motion to disqualify. November 14th, Murphy receives it, reads it, and acknowledges that Bradford asserted that the JSS file contained, quote, extensive amounts of privileged materials. November 16th, he gets our emergency motion to prevent him from giving the documents to the court. The emergency motion says, return the JSS file. November 16th, he meets with Birch and Cracchiola attorney Laura Myers and asks her to conduct research into work product and attorney-client privileges. November 16th, she conducts legal research on ER 4.4B, an inadvertent disclosure. November 17th, she meets with Mr. Murphy to discuss her research. November 17th, Murphy does his own research. November 17th, Laura Myers does additional legal research on ER 4.4B. November 17th, after he's had legal research done, after he knows what 4.4B says, after he knows about inadvertent disclosure, and after he knows that we are unequivocally asking for the files to be returned and unequivocally saying that they contain privileged materials, November 17th, Mr. Murphy reviews the JSS files again in detail, specifically to address the issue of prejudice, including his prior knowledge of what was in the file. There's no inadvertence here at all. Now, if we go back to its original...
Does any portion of that comport with 4.4 or 26.1?
No. Your Honor, the issue of whether the documents are privileged or not is left to the court. You don't get to review them and make that determination yourself. 26.1, F2, and 4.4B says you stop, you sequester, return, destroy, or file under seal, and you do nothing with the documents until the issue is resolved. And it's not Mr. Murphy's right to decide whether they're privileged. It's the court's right to make that decision.
Take us to the next step. Counsel says the only thing we have to decide now is should the documents be released back, right?
Well, that's
should they be returned back to Mr. Murphy?
Right, and they claim there's no harm. Now, first of all, Your Honor, they didn't appeal that issue. They appealed. Judge Gamble asked a question right at the start that I think goes directly to the heart of this. He said, is this issue even really before us? Because Judge Schwartz ruled that in-camera review by the court ex parte is sufficient to protect their interest.
Part of our issue here, though, is no one has a normal remedy by appeal here. So it appears that special action is the method for this court to review anything of this sort that's going on in the trial court. But help me understand what you're saying, that that's not before us.
Yeah, I'm not making a jurisdictional point. My point's a little different.
I thought so.
The only way you can grant the relief they're seeking is to overturn that order of Judge Schwartz and Judge Bassett that held that in-camera review is sufficient, yet they haven't appealed that order. Why didn't they just directly take the court on and say you did it wrong? Instead, we get this mismatch of quasi-constitutional, maybe higher review, due process, maybe waived not enough.
But aren't they bringing before us in this proceeding the ultimate ruling of Judge Bassett? And they're saying it should be set aside because we weren't given a fair process.
They're bringing exactly that question that Judge Schwartz and Judge Bassett ruled on. In-camera review is sufficient.
Well, I guess I'm thinking they're bringing a slightly different question. I'm thinking they're bringing a question of whether the documents needed to be given back to Birch and Cracchiolo before the disqualification motion was determined.
Well, but that is the issue, Your Honor. I'm sorry, you and I are kind of missing each other, ships in the night. But because...
It happens a lot.
Because the ex parte part of the in-camera review is what Judge Schwartz said is sufficient to protect them, and it's the ex parte part of in-camera review that they say they should have gotten the documents. But they don't just take the court on. And they don't do it for two reasons. Well, one reason, they would lose. But they lose for two reasons. One, the standard of review is abuse of discretion. It's up to the court how the court handles procedures before it. And number two, overwhelmingly, in balancing the various rights in privileged situations, our court and courts around the country have held that ex parte in-camera review protects everybody's rights. Now, what isn't before the court also today is the question of somehow Bradford would be harmed by this review. But let me tell you, he would. First,
By a further review by
By-
Birch and Crackiola,
by further review.
even if they were then disqualified.
Absolutely.
Okay, tell us.
Your Honor, the only way that you can reach that conclusion is to decide that the privilege really doesn't mean that much. Because there's not another situation in the law where we say repeated violations don't mean anything. If I drive across your backyard to get to the lot behind you, and you complain it's a trespass, and then I do it again tomorrow, I don't get to say, well, I did it yesterday, what difference does it make? If I rob you, if I break into your home,
Some of my neighbors.
they might object. They might be more forceful. The only way you get to that point is you have to disregard the privilege for what it really is. But in this case, we have a bigger problem. We have been faced, Bradford's been faced, with the ever-morphing factual dissertation of Brian Murphy. In front of Judge Schwartz, when he was specifically asked, he said, well, I just flipped through and barely noticed them. Then at the motion to disqualify, we learn he reviewed them in detail after he knew he shouldn't. Then, in front of Judge Bass on oral argument, he expounded on that. Neither of those two times did he say, but I forgot. I did back then, but now I don't. But now we hear, when we pointed out that that's what he did, that he actually did the exact review he complains he was deprived of, we now hear, well, yeah, that was 3 years ago and we don't really remember it. Well, what that means, Your Honor, it's not a situation where we're now showing him privileged documents that he's already seen and he remembers what's in them. We're showing him privileged documents that he doesn't know what's in them.
Counsel, let me ask you a question. Opposing counsel, appellant's counsel made the statement several times that I'm going to refer to it as the Schwartz-Bassett review. You with me on that?
Yes.
That was inadequate because they can't possibly have an appreciation for the inherent privilege or lack of privilege in those documents that would give rise to the determination that there wasn't a hearing necessary. They were in and of themselves sufficiently prejudicial. Can you address that?
Sure. That's what judges do. Judges never know what happened. They don't know what happened in a contract case or a tort case or any other case. Judges are always third parties who don't have knowledge, who the lawyers have to explain what happened. And in this case, they tell us that they could have done it. Just before their conclusion, on page 42, they say, short of detailing each and every fact B&C knew before receiving the JSS file, an inefficient and problematic approach to addressing the discrete qualification issues is not able to make those necessary arguments. In other words, they could have done it. It may have been inefficient, may have been problematic, but they chose not to do it. And the reason they could have done it is Brian Murphy reviewed these documents specifically to gain the information that they say they were lacking. Did he have prior knowledge? Were they prejudicial? And they don't raise that argument specifically because they were. And all we're trying to do is create a convoluted rule of law that will simply result in incentives for lawyers to put people like Brad Lund in the position of having to decide, do I let them keep going or do I waive my privilege?
As a very small matter pertaining to the record, I hesitate to even ask, but I'm a little unclear on a CD. Apparently at one point when the documents were sent back by Birch and Cracchiola, there was a CD that was sent along with it?
I don't recall, Your Honor. When they were initially sent out to everyone, they were sent out on a CD.
And just so I'm clear, that was a 26.1 disclosure send out?
Yes.
Okay.
And, Your Honors, as
You mean Mr. Murphy's
disclosure statement,
So when he sent out his disclosure, he sent it out on CD.
he did.
So the
Yes.
documents had been scanned.
So the documents had been scanned. And by the way, Mr. Murphy says, well, nobody else in my office has seen them. Well, at least the paralegal saw them. She scanned them. She reviewed them. Mr. Murphy designated these as trial exhibits.
People can scan documents without really reviewing them.
I guess.
I think I've seen it happen.
Perhaps. I may have done. No.
You just mentioned something that these were, and I remember that these were actually disclosed as trial exhibits.
Yes.
In other words, they weren't just general 26.1 disclosure of any and all documents potentially relevant. They were something that they were intending on using at trial.
Absolutely.
Tell me the ramifications of that.
Well, the ramification is Rule 11 says you have to, if you're going to sign that pleading, you have to have a basis for signing it. And it means Mr. Murphy had to have reviewed those documents, made a determination to use them as trial exhibits, and not just simply to disclose them as, oh, by the way, I have these. But he made that determination, and you can only make that determination after reviewing the documents. And by the way, all that happened before he admits that he had a detailed review.
Well, may I follow up on that? Yeah. And I'm sorry, but I guess my question was a little more, I guess, direct than that, not necessarily that obtuse. We've heard that the 2006 litigation was all these were about, and these were utterly irrelevant to anything in these proceedings.
I see where, exactly.
So why would you list them as trial exhibits if they were irrelevant, inadmissible, whatever you want to call it, to these proceedings?
You wouldn't. Why would you subpoena them? You wouldn't. Why would you call it a seminal event? You wouldn't. Why is it in your petition? It wouldn't be.
So in the preparation for trial, they're marked as trial exhibits intending to be admitted at the hearing.
That was his intention by disclosing them as trial exhibits.
I guess if this issue is crucial, and I guess I need to see and study the actual disclosure, but I recall in practice disclosing lots of documents that I wasn't sure whether I was planning to use them at trial, but I wanted to reserve that right, so you disclose them. There's a big difference between that and what you're describing as somebody has made a not very far ahead of trial conclusion that they're going to, these are actually going to be trial exhibits.
Your Honor, I don't know. I just know I try to make a distinction. I try to say, look, if there's stuff in my file that I have to disclose, here it is, I'm disclosing it. If I think I may use it as a trial exhibit, I disclose it as a trial exhibit. I think that's the way you're supposed to do it, but I'm not going, that's how I do it.
Maybe I've been away too long.
Your Honor, let me address two issues real quickly. The first one, let me address this Mary Shaperi case. Your Honor, there are 100 examples where I believe they've misrepresented the record or they've misrepresented cases. Let me give you one quick example on the record. They claim that I had possession of the JSS file on the day I sent the email to Mr. Murphy. They cite to Mr. Flood's affidavit, paragraph 15 of that affidavit. What that affidavit says is, at Mr. Shumway's request, we delivered the file to Bradford Lund. I didn't have the file then. I haven't had it in between. I don't have it now. But they continued. They made that misrepresentation twice in the pleadings here, and they continued to do it even though we've pointed out that it's wrong. Why? Well, they think it shades it colors things a little bit more if I had the file, but it's simply not true. Let me say something about O Builder. They quote the O Builder case, and what you were just told is that the O Builder case stands for the proposition that once you've seen them, you get to see them again. That's actually not what it says, and you can tell by looking at their brief. If you look at the old Builder case, which they cite, on page 8, here's what the court says. It's at the end of the first paragraph. Defendant cannot have it both ways. She cannot claim she has disclosed confidential information to Attorney Lee, yet refuse to make those disclosures to the court. It doesn't say the other side gets them. It says the court gets them. Let's go to Marriage of Perry. I missed something in reading Marriage of Perry the 50 times I read in the past.
Hate it when that happens.
I know. I think it's helpful, actually. In Marriage of Perry, wife brings a motion to disqualify, claiming the lawyer used to represent her. The lawyer responds and files 2 affidavits and 2 memorandums of law. Wife moves to strike them. I thought that's all the court had looked at. But it turns out, if you look at paragraph 14, after the hearing, and at the hearing the court restricted the testimony to non-confidential information. But at paragraph 14, the court says, lawyer, I want you to give me your notes and any other information related to your conversations that you had with Karen, the wife. Karen objects on appeal, and she says, hold it, I was not afforded the opportunity to challenge those. And it's in that context that the court talks about waiver. First of all, the waiver conversation is dicta, and the court admits it, because the court held there was no attorney-client relationship and there was no implied attorney-client relationship. Therefore, there were no attorney-client documents or communications. But the court said if there had been, there was waiver. But the waiver went to the court. It is exactly what Judge Short said. The court can protect, and we have cited you to 100.
Counsel, let me ask you, and forgive me if we go a little over time. You have indicated in a contract case that the court is a stranger to the contract, and in some respects you're right. But in that respect, the court and all parties have a copy of the contract. What other circumstances are you aware where the court, but something less than all parties, get the factual documents that the court's asked to consider in making an important decision like this?
Repeatedly.
This is very, it's pretty unorthodox from my experience.
Well, here in Arizona, the Cooper Tire case, there's a statutory privilege for protecting a newspaper or a news person's witness, informant. In that case, the court said it was okay to have an ex parte in-camera conversation about that witness, because to have it open with the other side would disclose the witness. In Cooper Tire, the conversation was about confidential business documents, and the court reviewed them ex parte to determine whether they came from somebody inside the company in violation of the order or somebody else, and that was done ex parte. The court said that's the way it's supposed to be done. In Schoenweiser, I'm sorry if I mispronounce it, but it involved coroner reports and pictures, and the newspaper wanted to publish the information, and the court said no, the newspaper doesn't get to see it. The court will review it ex parte in camera, and sometimes they don't say ex parte, but you can tell from the context that it's ex parte, because that protects the public interest. In disqualifying in a criminal case, I believe it's the Hansen case out of West Virginia, the court said there was a testifying confidential informant. The court said defense doesn't get to know. We'll do it ex parte in camera. In a criminal case, Your Honor, we have cited, there is a plethora of cases in a variety. I know I'm over, can I have a second? Here's
How about 15?
15. If you let me find my note, 15 will work. Your Honor, at the hearing, Mr. Murphy said the following, we quote it. The judge asked him, you took a risk when you decided to review these documents. You ran the risk that they might be privileged and you might get disqualified. Mr. Murphy said, that was my choice at that time. What they're asking you to do is take away the consequences of that choice and the risk that Mr. Murphy knowingly and intentionally accepted. It is harmful to Bradford, it is contrary to Arizona law and to multitude case law across the country. We think you shouldn't accept jurisdiction just because this is a bad case to do it on, but if you do, Your Honor, you have to uphold the trial court. Thank you.
Thank you very much. Because we ran over a little bit with Mr. Shumway, let's advance Ms. Gabbardine an extra minute. Give her 5 instead of 4.
We're generous.
Yeah, we appreciate the arguments that both of you are making, and
So I'll start
ahead.
where Mr. Shumway left off. The risk still exists. The risk that Mr. Murphy took in reviewing the documents still exists to him. If at the end of the day they're prejudicial, he's out of the case. Exhibit E, so it's tab 4, Exhibit E, is Mr. Murphy's affidavit, which he submitted in connection with the response to the motion to disqualify. So it's no secret the extent of his review of the documents. And I'll just mention to the court, the reason he looked at the documents after he received the motion to disqualify was precisely to do what we're trying to get him the chance to do now, which is defend against the motion to disqualify. He says, it's paragraph 18 I'd ask the court to look at. He says, in preparing the response to the motion to disqualify, he's looked through the documents and made an index of them. Because what he was getting ready to do, if the court will remember from the procedural history, is he was getting ready to turn these documents over to the trial court for an in-camera review of privilege. So he made an index in order to review the disqualification, in order to prepare to defend against the disqualification
was
motion.
already thinking disqualification is a possibility.
Well, it was after the motion was filed.
Oh, okay.
It was after the motion to file. He did research on whether prejudice was at issue and whether he would be
No,
able to use the documents in his defense.
I thought we were at an earlier point.
So the analysis,
Right.
the analysis that was gone through was that where there has been a violation of privilege, I need to go back and re-entrench my knowledge of the violated documents so I can defend against them?
He received the documents. He flipped through them.
Well, I understand that, but after the motion to disqualify came in, it was after Mr. Shumway had called and said there's privileged stuff in there. It was after Mr. Murphy had recognized that some portion of that was clearly going to be subject to claims of privilege. The way he wanted to defend that was going through every document one by one and re-entrenching in his mind and in his records what those contained.
To be able to defend against the disqualification on the prejudice issue, yes.
So to truly come to understand the documents and recognize all that privileged information.
To recognize from his perspective why it wouldn't be harmless, to be able to make the argument to the court.
But that's clearly inconsistent with 26.1 and 4.4, isn't it?
Well, all he knew at the time, I think it's important to know, the email, he didn't get a phone call from Mr. Shumway, it was an email, and it identified billing statements and a non-mentioned and a nondescript memoranda. That was all that Mr. Murphy knew was being claimed was privileged in that document at that time. When the motion to disqualify was filed, there was no privilege log filed with it. So Mr. Murphy, so if we're going to say that he can't use the documents to defend himself, this is the situation we have. We have Mr. Murphy inadvertently receiving the documents, flipping through them. If the rule is otherwise, if the rule is as the trial court set up, then he has to turn those documents over after they file the motion to disqualify, not looking at them at all, and then the trial court decides in-camera review whether it's privileged and whether it's prejudicial, without Mr. Murphy ever looking at the documents in detail to defend himself at all.
If I, well, I'm sorry.
No, go
Do you
ahead.
want to, Okay, changing the subject slightly, I understood Mr. Shumway to be arguing, and I may be poorly paraphrasing here, but to be arguing that the special action is brought at such a time and in such a juncture of the litigation that the wrong issue is being presented to us, and that Birch and Cracchiolo and has not challenged the special master and the court's precise rulings.
So the question is why we didn't file the special action when Judge Myers summarily affirmed the special master's ruling that there had been no waiver.
Maybe.
Excuse me, the waiver. Out of a respect for judicial resources, it could have been moot. Judge Bassett still, at the point when he took over this case, still could have decided, you know what, prejudice is a valid part of the Alexander test for disqualification. Mr. Lund, you haven't shown me any one document why there is this prejudice here. I'm not disqualifying Birch and Cracchiolo. That was still a very valid possibility at the time that the waiver, the legal erroneous waiver conclusion had happened. So it could have been a moot decision. And also, Judge Bassett reaffirmed that ruling by holding that the second wave of privileged documents that Mr. Shumway sent ex parte to Judge Bassett did not affect a waiver as well. So the real harm here was the disqualification. Organizing my thinking. I do just want to re-emphasize the situation Mr. Murphy would have been in if the rule is as Mr. Shumway is suggesting. He gets the documents, he flips through them, and then he has to get rid of them and fight a disqualification motion completely blind. The briefs mention the...
It isn't, and I'm furrowing my brow, and you noticed that, I apologize, but isn't that, if the documents appeared privileged on their face, and I'm not saying they do or do not, okay? But if they did, isn't that what you're supposed to do? To set them aside and say, hey, something isn't quite right here. I need to await further order. And if that's the producer saying send them back, or if that's the producer saying lodge them with the court and we'll duke it out, that's how you handle it.
On the privilege question, on the privilege question, yes, and that's the process that the Supreme Court set up here, an in-camera review for privilege. But importantly, the Supreme Court reversed the Court of Appeals' decision that this was a violation of the civil procedural rules for Mr. Murphy to sit on the documents, to sequester them. He could do that at the same time as turning them over to the trial court for a question on the privilege issue. But the rule we're asking you to adopt would be that he gets them back when we move away from in-camera to prejudice.
My point is that the tactical call to dive deep into the documents in response to a motion to dismiss has enormous risk if you're wrong. And I understand you weren't at the table, your firm wasn't engaged at that time. But tactically, if they'd been flipped through for just a few minutes when they were received and then never looked at again, isn't that really maybe option A in defending against a motion to disqualify?
It could have, yes, and Mr. Murphy tried to make that argument. We're beyond that now.
And I understand that.
And but my point is,
I completely understand that.
That risk is here still. I mean, there's just no further harm to Bradford Lund because the risk is still alive, still very much alive. We're asking for a fair and meaningful process.
Your time is up,
Oh,
so we need you to stop or summarize briefly.
I'll ask the court to look at the O Builders case and the Flores case on the in-camera question.
Sorry, can you repeat what you just said?
I would ask the court to look at the language in the O Builders case and in the Flores v. Cooper tire case.
Thank you, counsel.
Thank you.
All right, thank you, Ms. Gabardine. Thank you, Mr. Shumway. You've made good and powerful arguments. We'll take the matter under advisement. We'll probably accept jurisdiction, but I'll have to confer with my partners now, and then a decision or opinion will be forthcoming after that. The stay will remain in effect.